Recording in progress.
Good morning, Tebuho. Alan, do we correct?
Good morning, sir. Yes, we do.
Okay. I have a challenge with the gadget that I'm using. I don't know what's the problem. What is this thing? Can you hear me, Tebu?
Yes, sir, we can hear you.
Okay, thanks. There seems to be a challenge with my gadget. It's not a problem. Let's start. We're 3 minutes behind time. Let me welcome members of the standing committee. You are all welcome. Welcome officials from National Treasury, other entities that report to Treasury. Welcome the parliamentary support team, PBO, SCOF support team, legal and all other teams, communications. Welcome the stakeholders that are here to make submissions for the bills that we are going to treat process this morning. We have got almost 3 stakeholders. Yeah, you are all welcome. The meeting is officially open. Are there apologies?
No, sir, I didn't receive any apologies for this morning.
Okay. So if that's the case, let's move to item 3. How much time, Tebu, are you allocating to each stakeholder?
15 minutes, sir.
Okay, 15 minutes. The Institute of Retirement Funds in Africa, are you ready? Are they in the platform, Sister Tebu?
They present first because they are at a conference.
Pardon?
I'm saying I don't see them on the platform, and they requested that they present first because they are at a conference so that they can go back to their conference.
Okay. Okay. Try to call them. Then we move to the next stakeholder, Asisa. Are they in the platform?
Yes, they are, sir.
Okay. Asisa, are you there?
Yes, I'm here.
Okay. Please proceed with your submission. 15 minutes allocated to you. Over to you.
Thank you very much. I'm unable to screen my share with the presentation. Tibor, will you share the presentation?
I'll give you sharing rights.
Okay. Still says disabled. Still disabled. I can't screen share, it's disabled.
Who's muting?
There it is. Just find it.
But we can't hear anything.
Yeah, but I think our sound is broken.
Okay, everyone ready? Good morning. I'm Audrey Messerschmidt, representing Asisa today. Who is a CISA? We are representing our members, which are retirement fund administrators, investment managers, long-term insurers, and collective investment schemes. These are all service providers to retirement funds. Our members understand the administrative systems and other business processes that the introduction of the two-pot system will require. And we interact regularly with retirement fund members and understand the difficulties they often face. We welcome the introduction of the two-pot system. We believe that it will ultimately have a fundamental positive impact on the capital available to fund members on retirement. We, however, caution against unnecessary complexity that would result in fund members being confused and distrustful of the system, complications for SARS's administration systems, and complications and additional cost for administrators, and therefore for funds and their members without any clear benefits. Our concerns, I'll list them and then go into a little bit of detail on each of them. The biggest concern is the implementation date of the 1st of March. We believe a rushed implementation will create problems. Our members are strongly opposed to the seeding requirements, but if it is included, the maximum of 10% with a cap of 25,000 Rand must not be increased so that the liquidity and systemic market risk can be managed appropriately. Tax directives on intra-fund transfers and withdrawals from the savings component is highly problematic. We don't believe it's necessary because it will present administrative issues for fund administrators and SARS. Intra-fund transfers between components in the same fund, we believe, should be removed from the proposals. Provident Fund members over age 55 on 1 March 2021, the so-called T-Day, should opt in to the two-pot system and not opt out as the legislation is currently framed. Legacy retirement annuity exemptions, the draft explanatory memorandum talks about an authority for the FSCA to grant exemptions, but there's nothing in the draft law or current legislation to facilitate that. Further exemptions are also required, for example, funds in liquidation, beneficiary funds, funds that have only pensioners as members, and dormant or closing funds, and for certain categories of members such as pensioners. And basically the reason because they don't contribute to the fund anymore. Then amendments to the Pension Funds Act that are not required for the two-pot system should be excluded from these bills. And we believe drafting of several amendments needs improvement and clarification. And the non-alignment of certain Pension Fund Act amendments with income tax amendments need correction. Okay, on the implementation date. We've previously highlighted extensive work that will be required to implement the two-pot system. And all of these issues are covered in our written comments that we submitted to you. The fact that National Treasury have published the discussion paper 2022 and the 2023 Revenue Laws Amendment Bills for comment over the past 2 years is only of limited assistance. There's still much uncertainty on important aspects that remain unresolved, and important details are not finalized. Effective communication and explanations to retirement fund members need to be produced and rolled out in different ways to different sectors of fund members. With various aspects that remain unknown or uncertain, communication before publication of final legislation risks confusion. SARS will need to make its systems ready to administer the extensive additional work that the two-pot system will require of them. The FSCA will also need complete certainty before their staff can be trained to deal with these changes, noting that every single retirement fund in South Africa will need to change its rules and submit those changes to the FSCA for approval and registration. FSCA cannot register rule amendments before the law is gazetted. Complete certainty for all affected parties can only be achieved once the final legislation is signed off and promulgated. Fund administrators need 12 to 18 months from that final publication to change their systems, fund rules, member communication, and obtaining member choices, member option choices before implementation. Regrettable, we believe that the two-pot system is highly beneficial and should be implemented as soon as possible, but 1 March 2024 is not feasible. On this slide, I put boxes of everything that needs to happen before the system can become effective. I'm not going to run through of all, that will take me another 15, 20 minutes to run through every single element and everything that that needs to happen inside of each of these boxes to make sure that members or industry participants will be ready for the effective date. Seeding is our second concern. As I indicated, our members are strongly opposed because it will undoubtedly erode the retirement savings of fund members. And if it is included, the caps are very important to manage the liquidity risk in the funds and also the impact on the financial system with mass withdrawals. Similarly, seeding should be a once-off event. The transfers between components within a fund is also problematic. Transfers from the savings component to the retirement component and from the vested component to the retirement component in the same fund, we believe should be removed from the proposals. They should not be allowed because there's no benefit to the member in transferring from one component to another while you're still a member of the fund. This can be done on retirement. The disadvantage of this transfer before retirement is that it is irreversible. There's a risk that a members request the transfer because of lack of understanding of the irreversible consequences, and once the funds are in the retirement component, they cannot be accessed at all until retirement. The approach in the draft amendments is legally flawed. An accrual to the member does not take place if the funds are transferred between components, and hence an exclusion from it's not a accrual, and a tax directive requirement is not appropriate. These transfers would add an unnecessary level of complexity and therefore costs to administration. Tax directives on intra-fund transfers, those are transfers between components within a fund, and withdrawals from the savings component is highly problematic. It's not necessary. It will present administrative issues for both SARS and fund administrators. Intra-fund transfers are transfers made at the election of a fund member to transfer from one component to another. The word transfer is actually not correct. You remain within the same fund. It is simply a reallocation from one notional account to another. There's no movement of funds. And to require a tax directive in this event is unnecessary and unreasonable increase in administration and cost. Withdrawals from the savings component will be allowed each tax year. It's probable that the majority of fund members will access their savings component annually. To require administrators to apply for tax directives on each and every savings component withdrawal request will present administrative issues for fund administrators and probably also SARS. An alternative needs to be found in consultation with administrators and SARS, a simplified process. For Provident Fund members that are older than 55 on 1 March 2021, the so-called T-Day, the default position is that these Provident Fund members are to remain in the vested component only if they elect to do so. This means they are automatically in the two-pot system unless they elect otherwise. That is how the legislation is drafted currently. It's impossible to communicate with affected members to explain and request their election in such a short time until 1 March 2024, when administrators will have to allocate contribution and seed capital to the savings component. We believe strongly that the default position should be reversed, that these members should remain in the vested components unless they specifically elect to be in the two-pot system. They should opt in and not opt out. As I said, proposed legislation provides no opt-out of seeding capital for Provident Fund members. So even if they do opt out of the two-pot system, they're forced to have a savings component with a seeded amount and pay tax at marginal rates on withdrawal. The Legacy Retirement Annuity Fund exemption, there's a definition in the proposed amendments to the Income Tax Act, but the term is not used anywhere in the proposed legislation. The explanatory memorandum refers to a declaration to the effect that the fund complies with the definition being submitted to the FSCA, but there's no mention of this in either the proposed amendments to the PFA or the ITA. There are also no proposed amendments in the Pension Funds Act in terms of which the FSCA would have any grounds for requiring or noting or dealing with any such declaration. And there's no authority in the draft law for the FSCA to grant any exemptions to retirement funds from the provisions of the Income Tax Act. Therefore, amendments to the Income Tax Act and Pension Funds Act are required to facilitate exemptions of affected retirement annuity fund members. Most retirement annuity fund members with the legacy products also provide non-legacy products, so the exemption should apply only to those members with legacy retirement annuity policies. The exemption needs to ensure that it covers the exemption from the creation of the various components and exemption from seeding. Other exemptions are also required, for example, funds in liquidation, beneficiary funds, funds that only have pensioners as members, and dormant or closing funds, and for certain category of members. Various drafting proposals for clarity and certainty are set out in the ASISA letter and detailed comment on the provisions of the bill. We believe that the amendments to the Pension Funds Act that are not required for the two-pot system should be excluded from these draft bills and be dealt with in the conduct of financial institution bills. These are the definition of pension interest for the purpose of divorce orders and proposals with regard to future maintenance payments. These need separate consideration and consultation, including possible concurrent amendments to the Divorce Act and the Maintenance Act. To avoid holding up the implementation of the two-pot system, the only legislative amendments to the Pension Funds Act at this stage should be those required for the two-pot system. The implementation of this system will be complex, and unrelated items that will require simultaneous implementation, we believe, is unreasonable. There are several areas where the drafting of the proposed amendments need improvement and clarification. Significant concern is non-alignment of certain PFA and ITA provisions, such as the Section 37D deductions. The Income Tax Act proposes these deductions are made from only the retirement component and the legacy or vested component, but the Pension Funds Act proposes deductions from savings component as well as the retirement and legacy or vested components. One of the drafts must be incorrect and needs correction. Our members support deduction across all three components proportionately. The two-pot system proposals introduce a significant change to the retirement system in South Africa. CISA members support the broad principles and aims of the system, and once all legislative amendments are gazetted, much work will be required by our members to implement the system. We do not support a rushed implementation. It would cause confusion and be extremely unfair to retirement fund members who need to be in a position to make informed, timeous decisions about their retirement funds and their retirement planning in general. Thank you.
Thanks, ASISA. Is the Institute of Retirement Funds in Africa in the platform now?
Yes, we are. Thank you. It's Nancy Andrews.
Okay, you are welcome. And
Thank
please
you.
make your submission.
Do you want me to share the presentation?
We will appreciate if you can share.
Okay, so the presentation mode is disabled.
Tebogo, what's the problem?
No, I have given her hosting rights. I think she should try again.
Please let me know if it's sharing.
Yes, you are on the platform, Nancy. You can see the presentation.
Thank you. Good morning, everyone, and thank you for giving us the opportunity to present at today's meeting. On behalf of the IRF, I think it's appreciated. And in light of what has been actually presented by CISA, a lot of what we are going to actually present on is in support of the submission we've made as an industry, as the industry as a whole. So we looked at the Revenue Laws Amendment, the Pension Fund Amendment changes, or the consequential amendments to the pension funds. And like it was earlier said, there is a concern around the misalignment with the definition, with the issue on calculation of liens against a pension fund and how it must be deducted. In support of what CISA has actually said, we as IRF support that it must be deducted against all three pots. And the misalignment which allows for the deduction, the calculation against the three pots in the pension fund amendments must be aligned to what is contained in the income tax amendment. So our understanding, our submission is, or our proposal is, and it's in our comments, is that it must, the calculation of what the lien is must be against all three pots, must be used in that calculation. And in terms of the deduction, it must actually flow from all three pots. Again, our second submission is around COFI and the fact that the COFI changes that were brought through the consequential amendments. We again believe that this should be postponed to this should be brought in when COFI comes in and not right now. We're under a lot of pressure to actually deliver on the requirements for two pots, and this added the introduction of these added provisions actually makes it difficult for retirement funds to manage everything at once. One of the big issues we picked up in the pension funds amendment is that the retirement funds are referred to as licensed entities, which is not currently in the pension funds legislation. So it's not aligned to the current Pension Funds Act is not aligned to COFI as yet. So certain provisions need to be kept, should be held back until COFI is actually implemented. Rules registration, I think this is a big concern because implementation of two-part is subject to the rules being amended by the FSC, amended by the funds and approved and registered and approved by the FSCA. The concern for us is that whether the FSCA would have the capacity to actually be able to do this on short notice, given that we're not certain when the expected date of this legislation will be promulgated. So again, implementation date, we support the postponement of it, because only when we see the final piece of legislation would we be able to put rules into effect, which would be subject to the approval of the FSCA. We are concerned about Section 14 transfers, particularly those ones that are in transit, and the fact that you could actually have a seeding amount from each fund. So we need to, in our submission, we requested clarity on how that would work, given that your seeding is actually if you're in a Section 14 transit position, you could have seeding capital from both funds, your transferee fund and your transferor fund. From a revenue laws amendment perspective, again, we support the opt-in provision versus the opt-out provision for members, for particular categories of members. Those are Provident and Preservation Fund members 55 and over on 1 March 2021. We believe that we've always been told by National Treasury that in any piece of legislation that's implemented, vested rights have to be protected. So we have proposed in our submission that this should be an opt-in provisions for members over 55. The same in regards to paid up members, because they've already got a vested right to automatically give them seeding does take away that vested right of having to be able to withdraw it in full. And then Preservation Fund members who have not exercised their one pre-retirement withdrawal should not be actually brought into the two-part system unless they opt in for it. Again, this was discussed through CISA in terms of which funds should be fully exempted from two-part. Our submission is the same. Beneficiary funds, funds that have pensioners and no contributions as at 1 March 2024. Dormant closing funds, any funds where there's a liquidator has been appointed by the FSCA as at 1 March 2024, and funds that are currently in the process of termination and cancellation through the FSCA. A concern for us on the liquidation is that when a liquidation is in process, there needs to be an adjustment to the wording, to the definition of savings component. It actually allows you to take benefits out when you to your vested component and savings component to withdraw those benefits if you leave employment. On liquidation, we have a problem with it because you don't leave employment. So what happens to the different components? We have made that submission in to National Treasury, so we wait to see what comes out of that. Partial exemptions, I'm not going to cover this slide because ASISA has covered it, and we have actually supported this as an industry in respect of which funds we believe should be partially exempt from the two-part legislation. And then again, the issue on transfers, we see that the transfers between the components, which is inside the fund, is a reallocation between the components. That should not be allowed during the course of, we propose that it should be allowed at a point at which the members and exit event is taking place in terms of the rules of the fund to prevent members from reversing a decision which is irrevocable. So again, on this here, we do not believe that there's a tax accrual event. It should not be a tax directive process for which funds need to do. And then with intra-fund transfers, we understand that to be transfers between two registered funds, so we're quite happy with that particular position being subject to tax. It is as it stands now. One big issue that came up and was part of our submission is the staggered payment of the bulk claims that we may receive from 1 March 2024 if this legislation goes ahead. And a big concern would be because of the bulk, there could be delayed claims, delay in payment of claims. So we actually requested that there should be a consideration for a limited period as amnesty from these complaints being lodged with the pension funds adjudicator. And that's all from us. Thank you very much.
Thanks for your submission, IRFA. Kosato, are you there?
Good morning, Chair. We're here, and we can present from our side if we're given sharing rights as well, Chairperson.
Okay, thanks, Comrade Matthew. Tebogo, can you share with COSATU?
Chair, can Nancy just disable her presentation, please?
Okay. Nancy, are you there?
Apologies. Thank you.
Pleasure.
Jack, yeah, I can share as soon as I have hosting rights, Chairperson, or sharing rights. Okay. I think it's coming up. Apologies for that, Chair. Just 1 second, just to share quickly. Sorry, just one. Apologies, Chair. Just 1 second.
Okay.
Sorry, Murphy's Law. Hopefully it'll work now. Apologies for that. I'm not seeing it now, Chair. Sorry, no, I do see it. Apologies, I do see it. Okay, hopefully that's it, Chair. Apologies for the gremlins. Good morning, Chair, and good morning to members. Thanks for giving COSATU a chance to make our submission on these two bills, the Draft Revenue Laws Amendment, Administration Amendment Bill, and also the Draft Revenue Administration and Pension Laws Amendment Bills, or the two-pot pension bills. So I think, Chair, maybe just to indicate why COSATU is here, it's because this is a huge importance for our members and for workers. Our members are pension fund members. These pension funds that we're talking about are workers' monies. They don't belong to the state. They don't belong to pension funds or the private sector. They belong to workers, and they remain workers' deferred wages. And this is a very sensitive, very emotional, long historical issue for workers. So I think we should just bear in mind that this is the property which belongs to workers, belongs to no one else. And the law is meant to assist workers in this regard. So, Chair, COSATU, we want to support these two bills, the two-part retirement proposals. And we and workers at large are looking very much forward to the 1st of March 2024 implementation date. We think, Chair, this has been a long journey. This has been a product, the two-part pension reform discussions has really been a product of long engagements since 2020 between COSATU and Treasury. And the idea really is about giving relief to millions of workers, but also to see how can we fix existing legal loopholes, or legal problems rather, in the existing pension laws. And at the same time, appreciating the need to help boost pension savings as well for workers, for pensioners, for the economy, and so forth. Whilst we welcome these bills, Chair, we're deeply concerned about two parts of it. One is the immediate relief for when the law comes into effect on the 1st of March 2024 of 25,000 Rand for the cap. The second one is Treasury's proposal to increase the tax rates for early withdrawals to the personal income tax rate. So I think for us, Chair, these are two critical matters we hope can be resolved. We think they can quite easily with some political will. But we really think it's critical that we resolve them to ensure that the relief workers do receive is meaningful and is not symbolic. It isn't watered down extensively. So, Chair, our support for these two bills, what is that we had engaged with Treasury on this thing since 2020, and we welcome that we managed to find each other, even though at the beginning we were really at arm's length from each other. But in many areas, we managed to find consensus. One is that workers would be allowed access to the savings, the pension funds, apologies, without having to resign or cash out the entire pension fund right now, which is the current legal challenge. That if you have some sort of family emergency, whatever the situation might be, medical emergency and so forth, the worker's only option currently under the law is that you have to resign from your job and thus you're unemployed and no longer contributing to a pension fund, and you have to cash out an entire pension fund. And say, for example, you had R1 million pension fund, you maybe only needed to access 100,000, but the law currently doesn't give you a choice. So it is the worst of both scenarios. We appreciate that Treasury has agreed to our proposal that some immediate relief should be made available to workers when the law comes into effect on the 1st of March next year. And the rationale here is that workers have waited a very long time for this. They're literally drowning in debt. And we want to avoid a situation where we frustrate workers who then choose to resign, as opposed to just simply giving them some limited access. Because if you made the law only going forward, it might mean that workers must have waited another 2, 3, 4 years to have some savings to assist them. And we want to avoid the situation right now where workers do all the time resign and cash out everything. We welcome that this is going to cover all workers, all pension funds, including the government employee pension fund, because literally all workers are struggling. And yes, a public servant might be receiving a salary and so forth, but they're covering a spouse who has lost their job or has lost wages. No one is left untouched by the economic hardships that the country is experiencing. We appreciate this will be binding upon all pension funds. The pension funds will not have the right to deny any worker access to the immediate relief or to the savings pot in future. And whilst they haven't concluded the exact wording, but we do appreciate the agreement in principle from colleagues in Treasury that a worker who is retrenched would be able to access the full savings. A worker should not be penalized because they've lost their job and yet they're in a real crisis. So you wouldn't want, for example, a worker who is now unemployed in danger of losing their house, yet they have got pension fund savings which could have helped to secure the house, protect the property, protect the car, retain the medical aid membership, take care of the families, etc. So, Chair, we also do believe that it's always a bit of a slightly daunting experience to tinker with pension laws, but we are taking comfort that the two-part reforms have received support from many pension funds. Alexander Forbes, being a spokesman for it, has come out publicly in support of it, and so forth. So we think Chair is going to achieve many positive things. It's going to boost savings, which is critical to the economy, critical to ensuring pensioners don't retire in poverty, as most currently do. It's going to give, some relief to workers who are literally drowning in debt. And of course, that money, when it's given to workers, is going to help workers pay down debt. They'll take care of medical emergencies, home repairs, whatever the sort it might be. And that's money that's injected into the economy and so forth. We appreciate it because it's going to help prevent workers needing to resign to access a limited portion of the pension funds. There are compromises from workers' side too. For example, that 2/3 of future savings will be preserved for retirement or retrenchments. So that's going to be a significant boost to the savings regime, where currently only about 6 or 7% of workers actually can afford to retire. In simple terms, it's going to give workers, in essence, an annual 13th check, the immediate relief next year, and then going forward once a year, if they wanted to access the 1/3 of annual contributions going forward from the savings pot. And of course, it enables workers to remain employed and receive relief, and that helps to disrupt productivity at companies, etc., which have invested in these workers' skills. We think Chair also is going to benefit the economy because this will be money injected into the economy from the savings pot to the pension funds. It's going to give additional revenue to the fiscus as well, because when you spend money in the economy, the fiscus also recovers some of it through company VAT, income, and utilities taxes. So it would be quite a significant stimulus to the economy in effect. So, Chair, we had a lot of discussion with Treasury on the immediate relief, and first, this is really critical because workers are drowning in debt. If you look at the National Credit Regulatory reports, it just shows you how deep in debt workers are, public sector, private sector. And workers have been waiting for this since 2020, since we've been discussing it. And we think, Chair, it is critical that the immediate relief should be meaningful. So we had discussed, and I'm sure honorable members will remember in 2020 when we had these discussions, we had discussed an amount of 30,000 Rand in 2020, a little bit less than Honorable Dr. George's draft bill that time. But 30,000 made sense in 2020, but it's been badly eroded by CPI since that time. We've had a significant increase in CPI since, peaking at about 7.6, 7.8%. We've seen 18% electricity tariff hikes this year, 12% next year. Fuel is about 25 Rand a litre, and I think in October is going to push to about 28 Rand a litre, and other price hikes. So it would not be justifiable, morally conscionable to come with an amount in 2020 and then say, well, in 2024, that amount should have remained the same. Also, Chair, that 25,000 Rand amount will be subject to tax. Now, currently under the tax, the penalty rate for early withdrawals is about 18%, if I'm correct. The proposal from Treasury is to raise this to the personal income tax level. So depending upon your income tax level, that could take you to a 20, 25, 30, 40%, depending on your income level, tax rate. So you might find that 25,000 Rand ends up becoming 15,000 Rand. And this has become a huge point of distress and has upset workers significantly. And we really want to turn a very positive victory and let it remain a positive victory. We don't want it to become a bitter pill. We've been flooded with comments from workers who support these proposals, but the sticking point has been that 25,000 Rand is not enough. Let it be 50,000 Rand. We've told workers, look, it can't be 100,000, it can't be 20,000 because you'll collapse the pension funds, you'll collapse the economy, put retirees into poverty when they retire. But let's make it a little bit more substantial than 25,000 Rand. So proposal in essence on this one, Chair, is to raise the 25,000 Rand to 50,000 Rand cap, ideally post-tax, but at the minimum, let it be at least 50,000 Rand. Then, Chair, the second kind of area of concern is around the taxation level. So we appreciate, that tax incentives are there to help incentivize workers to save for retirement. And of course, the tax penalties exist to discourage early withdrawals. That's fine. We think the status quo tax regime is sufficient to achieve that. Workers are not choosing to withdraw early because they want to go on a holiday to Mauritius. They're choosing to withdraw early because they're simply not coping. And they're trying to avoid the family being left homeless, or whatever the situation is, to take care of a wife's medical emergency and so forth. So we're really quite shocked and disappointed that Treasury has proposed to raise the tax rate from the existing withdrawal rate to personal income tax. And again, this is going to see workers' relief really being hit by huge taxes, and often the relief being significantly watered down to the point of being meaningless. And we want to also avoid a scenario where people in this day and age of social media, etc., would simply say, well, Treasury is now profiteering from workers' misery. It shouldn't be that way. This is, again, workers' money, and it's fine to give workers an incentive to save, and it's fine to recover that incentive when they withdraw, but we shouldn't be profiteering as a state from workers' struggles. So the proposal in this regard, as COSATU Chair, is simply let's keep the current tax rate as it is, and let's not link it to the personal income tax rate. Then, Chair, on the issue of retrenchments and dismissals, so this isn't in the current bill, but I think we need further discussion. It's fine to come with a supplementary bill next year. But it's critical that when workers are retrenched or dismissed, they should retain their existing access to their pension funds. Workers, when they lose their jobs in this economy, will struggle to find another job. When you have an unemployment rate of 42%. And again, people ask, so why must you allow workers? Well, one, again, this is their money. But two is that you want to allow workers to use their savings, their funds, to save the houses, the cars, retain the medical aid membership, feed the families, etc., whilst they try to find another job. Yes, you will not do this in an ideal scenario, but we don't have a luxury of a comprehensive social security net like, for example, you might have in Sweden. Here, workers are on their own. So when they are facing this crisis, they should be allowed to tap into whatever they have. Someone might say, well, the UIF is there, but UIF doesn't cover all workers. There's about 4 million workers it doesn't cover. And also the amount of relief it gives is quite limited. It's not sufficient, as we saw during COVID-19. So we're pleased that Treasury in principles agree to this concept. I think it's critical that we find some modalities to flesh it out if not this bill, then in the next bill next year. So proposal in essence here is that workers who are retrenched or dismissed need to be allowed to continue to have access to the pension funds. Some might ask why dismissal. Well, often employers dismiss workers for spurious reasons. Chair, on the issue of the 2024 implementation date, look, for us, this is a red line as COSATU. We've started those discussions with Treasury in 2020. In the October medium-term budget statement in October 2020, the then Minister of Finance, Mboweni, committed to a 2021 implementation date. Treasury dragged this out, then it became 2022. It became 2023. Treasury this year committed firmly to 2024. We don't think it's fair to workers to say, let's delay it even further. And of course, you delay matters further during an election year like next year is, you could then be talking about 2026 and beyond. So one, that's not fair to workers who are really struggling, but desperate and hanging on for this bill. And this is a very, very popular bill. Workers are very keen to see it happening. But the other negative consequence, if we delay further, those workers will just simply give up and they will just simply resign and cash out, which is what all of us, I think, as government, as trade unions, as employers, as pension funds, all of us want to avoid. So we should allow this thing to happen by 2024 March, allow workers some immediate relief. They're not going to get everything they want, but at least to give them some relief and some hope. So we think, Chair, proposed in this essence is that 1st of March 2024 is sacrosanct. The implementation date must be stringently adhered to, and all the necessary legislative and administrative processes should be undertaken, and we should really ensure collectively this day is not pushed back. Yes, we appreciate the difficulties the pension funds will have in adjusting the systems, etc. But let's also compare ourselves to the struggle that workers are experiencing, and we should not really push this thing any further. I think, Chair, for us, the remaining processes, just to getting towards the end, is to make sure the 1st of March happens, that these bills are tweaked slightly to make sure the relief they give meets the objective, that we can find ways to resolve the two major fundamental issues on a sub-policy issue, is to increase the 25,000 immediate relief to 50,000, ideally post-tax, but at least the 50,000, and just simply to retain the existing tax rate for early withdrawals. Of course, it means that Treasury needs to engage with colleagues at SARS and the pension funds to make sure they're ready for the 1st of March 2024. And of course, the regulations must be expedited by Treasury to ensure this happens, and the presidency to be engaged, etc. We think, Chair, once this bill is passed, we should have discussions, maybe even later this year with Treasury. We have some initial kind of discussions about further amendments for future, but let's get this one done. But looking at the issue that one, we need to address the issue of retrenchments and dismissals. So that's something that must be dealt with by next year. We might also need to have some discussions about, can we allow workers some sort of, with expand existing loan options to include education loans, for example, home loans, etc. That workers could take, surety from the pension funds, and many of these are long outstanding. Really, we should conclude them. But I think, in essence, our proposal here is that, with Treasury colleagues, let's expedite these engagements by the end of this year, so that, as we had kind of discussed earlier, that they could be ready for a supplementary amendment bill next year, and that could then come into effect in 2025. So, in conclusion, Chair, as COSATU and our affiliates, nearly 1.6 million members were very pleased with these bills, the overall thrust. We do welcome the constructive engagements we've had with Treasury and the significant amount of consensus we've had on this issue, including as well members of Parliament from all political parties. We think we do need to urgently resolve the 25,000 rand immediate relief amount and the early withdrawal taxation rate. And also, Chair, we cannot overemphasize that workers can't afford delays. We should be able to reach consensus on these matters. And this can really help to make sure this remains a positive victory for workers, for the companies, for pension funds, for the fiscus, for the economy. And I think lastly, Chair, workers are really depending upon all of us here collectively to make sure that this relief is meaningful and that it does happen on the 1st of March and beyond. So that's our presentation, Chair, and just to thank members for giving us space as COSATU. Thank you, Chair.
Thanks, Comrade Matthew, for your presentation. Teboho Alan, these were the only presentations, 3 presentations we have, isn't it? Are there other submissions?
No, sir, these are the 3 who wanted to make oral presentations. There's only one other that was sent through, but they're not making a presentation. They've written,
Okay.
just written it. Yeah.
Okay, let's proceed to the next item. Committee deliberations. Honorable members, there we are. Are there clarity seeking questions and or comments? Dr. George, over to you, then Honorable Mawiles.
Thank you very much, Chairperson. I will leave my video off because of connectivity. To Asisa, you mentioned that the Provident Fund members over 55 should opt in, not out. Why is that your proposal? And then you mentioned that March 2024 is not feasible. Why is that not feasible? I know that systems have been mentioned, etc., and quite a lot has to be done. We know that because this is a big change to the in the right direction to the pension regime. Yeah, I want to know more detail on why that is not feasible. And then to Cosatu, yes, if you look at the cost of living crisis that continues unabated, I would support a higher cap on the withdrawal. And also on the tax rate, I would support the use of the existing tax rate. Then on issues such as retrenchments or dismissal, it does make sense to have continued access in those events. And then also on the loans, my initial proposal was that loans should be considered also, because then a withdrawal does not need to happen from the fund. The funds can remain invested, and then the fund could be used as surety for a loan, but for a wider range of loans. So I would support that position also. Thanks, Chair.
Thanks, Dr. George. Honorable Mawiles.
Thank you, Chair. I think I will also on COSATU. I think, Matthew, I also agree with you. Two-pot systems is going to allow workers to access their savings without having to resign. And that is a big thing, because we know that if people are in need of money, some of them will just opt to resign. And this is just really going to give them a relief and help them not to do the ultimate to resign. And also, I also support, I hear your proposal about to increase 25,000 to immediate 25,000 to immediate relief to 50,000. I think now next is going to be next year. The cost of living will be a great higher. And for Asisa, I think I will just personally say to you, I think we will all need to work hard on this one. I suggest that you do whatever you can so that you make and sacrifice so that you make that this two-pot system is implemented, because I know that in principle you support it, but you have these problems. But if you are not going to do something and work harder, it will always be too soon. Now it's now here, and workers have waited for this system for a long time. So let us just do whatever we can to make sure that it's implemented. Thank you, Chair.
Thanks, Honorable Mawiles. Honorable Manyi.
Thank you, Chairperson. Firstly, I must apologize. I missed the roll call. But simply to say that, firstly, as the EFF, we welcome all the presentations. We think they've all been thought through. There's been no emotion in all the presentations. It's just factual things that affect people on their day-to-day. And the various submissions have been very technical in terms of making the kinds of submissions that were made. So what the EFF will do is to study them thoroughly. We got them beforehand, we've read them, but want to study all of them thoroughly and make a substantive response to all of them. Just one question to COSATU, though, is to say, in their election of a figure from this number to that number? Does COSATU not think that perhaps it would make more sense to rather use a particular percentage as opposed to absolute number? Because 50,000 means one thing to a member and something else to another, depending on your total reserve. So just that question, because otherwise we welcome all the presentations. Thank you, Chair.
Thanks, Honorable Moy. Honorable Mhlonishwa Skhosana.
Ngiyathokoza sihlalo bekodwa ngilotshisa wonke amalunga ahloniphekileko and also nama stakeholders akhona. We welcome all the presentations. On ASISA, yeah, I think they are raising an issue with the implementation date, which is the 1st of March 2024. They are saying it's not feasible when they look at things that need to be done after this law has been passed by different retirement funds, and the issue perhaps of consultation with their members, clarifying that and that. And I think in one of their slides, I think it's slide 8, where they say that fund administrators will need between 12 and 18 months from date of gazetting to finalize systems, fund rules, member communication, and obtaining member option choices before implementation. Of which it's a very good point that they are putting. However, Chair, when we take into consideration the fact that this process started in 2020, which is 3 years ago, and now say by the end of this year, this law is passed. Now, if you talk about 18 months, it means that will take us to 2025. So is it fair to workers who are in financial distress, who are swimming in a pool of debts, to wait for 5 years for this kind of a law? I don't think it is fair. As much as I think the issue that they are raising, it is quite important. But don't we have ways of fast-tracking all those processes that if this law get passed, say by end of this year, don't retirement funds have system to fast-track all those processes just to ensure that this law can be implemented as soon as possible? Because I think people who had the challenges in the year 2020, I think their challenges currently, they are even worse. So for us to expect them to wait for another 2 years, I don't think that will be fair to them. And things that are unresolved also, that they're talking about, I think in slide 7, I think this is part of the process also. The fact that this bill is before this committee and there are public hearings, I think it's also part of the process of coming together to close the gaps where there are matters that are unresolved. This is also part of that process because we've got this draft bill, but we're consulting with stakeholders. Afterwards, as a committee, we're going to look at the draft bill, look at the comments by stakeholders, and try to find a middle ground and put our own views and make a submission to the National Assembly. So I don't think post that there will be issues that will remain unresolved, because immediately this law is passed and gazetted, it means everything at that particular point shall have been cleared. So the only thing that will be remaining is the communication that retirement funds must communicate to their members, and also on their own they must make sure that they are ready for the implementation date. So I think for us to say retirement funds might need 12 to 18 months before they are ready for the implementation, I think it will be very much unfair to workers who are in financial distress since 2020 for us to expect them after 3 years to also say, please wait for another 2 years again. So that's a difficulty that I'm having on their submission there. Secondly, they are saying they are strongly opposed to seeding. And my understanding of the issue of seeding, the aim is to make sure that on the implementation date, there are funds on the savings account. Because as we speak, we don't have a savings account now. We've got only a retirement account. So by splitting these funds into retirement and savings account, that savings account, as we speak, is at zero because there's no savings account. So for members to be able to withdraw on the 1st of March in 2024, there should be something in the savings account. So hence the issue of seeding, to say, take something from the retirement pot and put it just to start the process for 2024. Then, but from the 1st of March 2024 moving forward, workers, they will be contributing separately to both pots. So if ASISA is saying they are strongly opposed to seeding, how are we going to make sure that on the implementation date of this law, there will be funds in the savings account if there is no seeding? And lastly, Chair, on the issue of Provident Fund members over the age of 55, we're over the age of 55 by the 1st March 2021. I think that the bill is proposing that they've got the right to opt out. However, ASISA is saying their view is that they should have a right to opt in. So I don't know what is the significant difference between that, because my understanding is that the principle in both submission is that they've got the right either to be part or not to be part. Because if you say they've got the right to opt out, it means if they don't feel comfortable being part, they've got the right to say, no, I am opting out. The member can say, no, I'm opting out of this system. But also if you say, let's exclude them, but they have a right to opt in if they want to, still in both ways, still mean the same thing, because the principle is that they've got the right either to be part or not to be part. As to whether you write it as saying they are part, but they've got the right to opt out if they want to, or they are outside, but they've got the right to opt in if they want to be part. But the principle is the same, is that they've got the right either to be part or not to be part. So why are they strongly saying that we should change it and say they've got the right to opt in, as opposed to say they've got the right to opt out? And lastly, coming to COSATU, I think they're making a very strong argument on the issue of 25,000 versus 50,000. I think all the reasoning that they've given, I think for me, I think it does make sense. Taking into account that this thing started in 2020, now we are in 2023. So if we're still talking about 25,000 at this stage, yeah, I think it might not be that helpful to the majority of the workers. So I think it does make a lot of sense for me. Thank you very much, Chair.
Let me go back to the stakeholders to respond. Let me start with the Institute of Retirement Funds. Over to you. Can you respond to the questions that members asked?
So I'm going to deal with the issue of Provident Fund members who are 55 and older and the opt-in provision that we're asking for. And the reason for this, and understandably, if you're in the position, you could actually opt out. The issue is that behavior of members of retirement funds is they don't often make an election. You have to constantly do the communication, and that communication has to happen before the implementation date, because if it's not done before the implementation date, they would actually be in the two-pot regime. So for those over 55 members, I think it's important to understand that they always have the right to have all of their benefits paid in cash if they actually retired from the fund of which there was a member on 1 March 2021. And by putting them directly into the system and not having an election made to opt out of it will actually result in them being prejudiced, because once you already created the savings component and the retirement component and your vested component in the fund, you cannot actually transfer your money out of, you cannot reverse that decision. So I think it's important to understand that they already have a vested right, and by allowing them to remain, to automatically stay in and opt out of it, we will not see them actually exercising that right as quickly as possible, which will end up being a problem for us at a later stage when you've already created the components and you can't actually change the rules around it. Thank you.
Thanks. And then let's move to Asisa.
Thank you for the opportunity to respond to questions, honourable members. Just to add to Nancy's comments on the over 55 annuitisation, she's correct in referring that they have vested rights that needs to remain intact. Must also be considered that if you were over 55 on 1 March 2021, when provident funds had to be annuitised, you were either close to retirement or in retirement. So the same is still true. It's 4 years later, and a lot of those provident fund members on that day are already in retirement or very close to retirement. So to force them to contribute to 3 components if they are already in retirement is not appropriate, we feel. Then the next questions are all about the implementation date. Or let me address the interpretation date first before I deal with the increased limit. So implementation, I think all of our members have been working very hard to do what they possibly can to prepare, but it is simply not possible to finalize the details without the outstanding law. It is entirely possible to finish the law by the end of the year, but it is impossible to put everything in place in 2 months' time to make sure that everything is ready on the 1st of March 2024. So let me provide a little bit more detail as to why that's problematic. So the retirement funds and administrators have to review all of their business processes and procedures to determine where changes are needed and to make changes and how those changes are to be made. Every single transaction involving a retirement fund, new contributions, transfers, withdrawals, retirements, reporting is affected by the two-pot system. Every client-facing document has to be reviewed and redrafted, and this must be done for every product and every product version. For, all of the detail has to be sorted out with internal and external parties. Charges, how the administration costs will be dealt with must be agreed. How to process divorce orders across the POTS components. For retirement annuities, pre-retirement withdrawals are not currently allowed. This means it's an entirely new system for them. There has to be adjustments to their actuarial basis. It has to be developed for a withdrawal to ensure an appropriate value for money to withdrawing clients while also protecting the solvency of the life insurer. Actuarial models the software and data feed needs to be updated, and those changes are quite complex. And this is required to comply with the financial soundness, IFRS reporting, and capital adequacy reporting to the Prudential Authority. Policy contracts must be adjusted to clarify the availability and the workings of withdrawals and to specify terms and conditions applicable to them. And also the withdrawal process. They've never had withdrawals, so a whole new process has to be developed. Information has to be provided to SARS. There has to be systems integration with SARS. The requirement for directives need to be clarified. The rates at which those withdrawals needs to take place has to be clarified. One has to deal with fund transfers and onboarding. You don't have the minimum information that you need to provide to SARS where benefits are being transferred between RA funds. That's a very complicated recognition of transfer process, which also needs to be updated. And that process is critical for the application of benefits into the appropriate pots on onboarding. So that is a little bit background on the administration. Then the boards of the retirement funds need to meet and consider and make decisions on, among others, how the allocations will work and the costs and the charges and the various variables. They have to decide how they're going to change their funds rules. So the rules about contributions, benefits, vesting, seeding, and transfers. They have to draft those rules. It has to be approved by the Board of Trustees and it has to be submitted to the FSCA. The rule amendments are not effective until it's registered by the FSCA. So the FSCA must review and approve those. I referred to the clarity on the integration with the SARS systems. As soon as we understand the system specifications that are necessary to implement all of this, the actual systems have to be developed. And I think everybody understands that you cannot develop such complicated IT systems in 2 months' time. Systems will have to be adjusted to administer a single policy plan investment in between 2 and 4 different parts. So it is referred to as the 2-pot system, but there's effectively many more pots. Vested rights before 2021, vested rights after 2021, and on implementation date of 2-pot, there will also be the 3 different components. So every transaction happening on every part is affected. It's an enormous amount of effort and time to implement. As I said, the administration system for retirement annuities must be completely redesigned. Currently, there's no withdrawals allowed from there. The allocation of the seeding value, they have to, for funds that don't have fund values, there needs to be models built to estimate the fund value on which to base the seeding value. And members need to decide, or our members need to decide, do they do this on 1 March for everyone or after the February contribution has been received? The transactional capability has to be built. This means keeping a record of every withdrawal so that there can be reconciliations. The capability for annual withdrawals is also completely new for pension administration systems. Certain transactions will result in current business volumes increasing by a factor of 4 or 5. So that is a fundamental re-engineering of current processes to accommodate the significant scaling up in terms of people capacity. So the fund is going, there's also a fraud risk that needs to be built into the process, and the compulsory preservation after the effective date, 100% of withdrawal claims will involve a level of preservation, which means that a SARS, ROT, a recognition of transfer is required. That process is currently extremely manual, and this will result in backlogs of members moving around. So the IT development can only start once the system specifications has been finalized. and the available IT capacity dealing with a number of changes is limited. Our members have augmented as far as possible to date, but the available capacity is very difficult to increase as the IT systems are very complex, and it's difficult to find programmers or developers that work on complex code that is very old that they don't know. So it's that is from there's limited resources as far as that is concerned for the highly complex system. It's not something that you cannot create that capacity in a very short lead time. So reports and member statements are used to show value to clients. These have to be revised, adjusted to show the separate balances of the different components. New entrance forms, investment switch transactions, and contribution allocation elections also need to be revised and adjusted. This means communication with the millions of fund members there are. The online member tools must be updated, and then there must be effective communication and disclosures to members produced and roll out to different ways, to different sectors, different types of retirement fund members. And the decisions they will need to make must be explained and understood so that members are in a position to make informed decisions acting in their own interests, as opposed to making uninformed, potentially irreversible choices in the heat of the moment. Trustees, employers, and members must be educated on how it will work, what it means. We can't start printing or finalizing marketing or education material until the regulations are finalized. That costs a significant amount of money to do that. And then also staff and intermediaries have to be trained on the different rules of the funds to make sure that the communication with members of the funds are appropriate. So that's quite a lot that needs to happen in 2 months' time. And that's why it is from a practical point of view, not possible to do that. And I mean, some smaller administrators or developers may be able to do this in a shorter period of time than 12 months, but the reality is everybody has to be ready at the same time. Otherwise, then there will be inequality in terms of who can access and who can't. And it is also very important that if you want to transfer from one fund to another fund, that both funds and their administrators are ready to be able to provide that service, to make the transfer and to accept the transfer. So that is the practical realities that we are faced with. We have sympathy for the workers, and we understand that they need access as soon as possible, but a rushed implementation is not going to help them make appropriate choices in terms of what they should do with their savings at that point in time. I need to emphasize that our members have sympathy, but we want to do it right, and we want to have everyone treated fairly and equally. That's on the implementation date. On the seeding, our members are strongly opposed to seeding, and the biggest reason for that is that it could cause major liquidity problems for funds. Funds are, pension funds are invested for 25, 30 years, and those investments often include illiquid investments that cannot be liquidated in a very short period of time. So what will happen is that the fund is most likely to sell some of its most liquid assets to be able to fund the withdrawals and the seeding, the withdrawals from the seeding. So that liquidity risk is significant. It could put a fund in a liquidity crisis if the seeding is not limited to 10% or 25% or 25K. The knock-on effect is that if the withdrawals are higher, it will have a significant impact on our financial markets. If that assets flows out of the financial markets, it will also have an impact on our economy. And I know there could be, backflows through taxes, but it won't make up for the potential liquidity shortfall and the systemic risk that it could cause in our financial system. So that is a very big concern. So we strongly oppose the seeding for those reasons. And if it goes ahead, we are very concerned that if the limit is increased further than 10%, up to 25,000, will further yeah, I went on mute, so I assume I've talked too long. Those are the biggest reasons. The liquidity and the impact on our financial markets as a whole is of a concern to us. Thank you. I hope I've answered all the questions. All of this is also set out in our submissions.
Okay, thanks. Kosato?
Yeah, no, thanks, Chair, and thanks to honourable members for the questions. So I think one just appreciates that you can feel the broad support for this very progressive bill across party line, which is always reassuring as well. So, Chair, just to Honourable Dr. George, I mean, in terms of the 25,000 rand, and even I think to Honourable Manyi as well on that point. When we had this first discussion in 2020, it was largely because sector clothing workers union had raised a proposal that the UIF was struggling to release the COVID-19 TERS to help workers. So workers were sitting at home with no source of money. And hence the proposal at that time was about 30,000 rand. We had also wanted to find the right compromise, a fair balance between giving workers some meaningful relief, but also avoiding depleting the tight pension funds, which would put workers in poverty when they retire. But to find what is the fair compromise. But 25,000 rand or 30,000 rand in 2020 is very different than 25,000 rand in 2024, let alone 25,000 rand in 2025 as the industry is proposing. It just doesn't have the same value. Not when you take into account fuel price, electricity hikes, municipal tariff hikes, transport, food inflation, etc., and that many workers haven't seen inflation-linked increases. So, and of course, now if you link that to an increase in the tax rate the Treasury has proposed, you might find that workers would get not 25,000 rand, they might get 15,000 rand. And compare what is that value of that. In fact, in many instances, it'll just simply be meaningless. You might buy some clothes, but you won't make much dent in terms of paying off some short-term debt, which is what most workers really want to do. We think, Chair, it's not a foreign concept to say that amounts should be adjusted for inflation to retain their value. In fact, if we look at the National Minimum Wage Act, it's stipulated in the Act that it must be adjusted every year to ensure that its value is retained and protected and enhanced. So I think for us, it's a common sense thing. The 25,000 in 2020 can't be treated as the same in 2024. Equally so, Chair, the tax rate should also be retained as is. Everybody hates taxes, no one loves them. But we think to sell an increase in tax rates to people who are heavily indebted, are struggling to survive, not through any fault of their own, but because of the failure of the economy to grow, because of the failure of us to be able to give them inflation plus increases. We shouldn't be penalizing people. And it will send a very ugly message that Treasury would be now profiteering in effect through a higher tax rate, because workers will be forced to withdraw to pay off emergencies. To Honourable George, on the retrenchment dismissals, look, we think that workers shouldn't be penalised because the company has dismissed or retrenched them. It's not their fault. Companies are retrenched because of economic circumstances. Workers are dismissed, often unfairly so, if you just simply look at the CCMA records, etc. And again, workers right now have the right to access the pension funds if they lose their job, and that should be retained. But I think that has to be dealt with quickly, that we should have some engagement with Treasury quickly on the modalities to it, and to make sure that in February's budget speech, there's a supplementary amendment bill, so that can come into effect by March 2025. And again, we can't afford this kind of legal vacuum for long. Chair, I think we've all often have discussed the missing middle, so to speak, and that right now many workers struggle to afford, for example, education treasury loans for the children at university. They may not qualify for NSFAS because their combined family household income might exceed that amount, but they also can't afford university fees. So I think it would make sense that just as you have existing capacity to take a loan for your house, etc., from your pension fund, that should be expanded to also include, for example, education loans, etc. That could be the part of a supplementary bill. And it could be a positive thing. It could also help to inject some level of competition in the banking sector, where often banks do exploit workers' desperation. To Honourable Mabileta, I mean, this is precisely the point, and this is the point we've made to colleagues in Treasury. We really need to find the right balance so we avoid resignations, because right now the law doesn't give you much options. It says if you're struggling, either suffer or resign and cash out. And that creates the worst of all scenarios, because now you're unemployed, you're no longer contributing to a pension fund, you've depleted your pension fund, even your workplace suffers because they lost your skills, etc. So that's why we've said, let's find the right balance. Let's give the immediate relief. Let's give the annual relief, etc. And we think in the longer term, it will be quite positive. So, Honourable Manyi, in terms of the amount, yes. So the bill also does provide the bill does provide also for a, what do you call it, a percentage up to the cap of 25,000 rand, and then of course annually, when you get the annual relief, you would have access to the 1/3 of your pension fund, which would go into a savings pot. So, for example, if your pension is 6,000 rand a month, a third, 2,000 in that instance, would go to a savings pot, and that one you could access once a year if you chose. You could access just a limited part of it. You could not access it if you didn't want to for a few years and allow it to accumulate, etc. So that's what we think is quite a positive thing. We think it's going to help to boost, incentivize savings. Look, we took the point that colleagues in Treasury had made. You know, many workers would call us and say, look, I've got R1 million, can't I withdraw 200,000 rand? And for sure, for them, that's only a small part of the pension fund. But we took the point that colleagues in Treasury had made that, look, we need to find a fair compromise. We need to avoid a run on pension funds. We need to avoid collapsing the economy. These monies are invested in throughout the economy, etc. And that most workers' pension funds is actually around 200,000 rand. And so that's fine. We appreciate in any engagement you have compromise, but the compromise shouldn't be so extreme that it disadvantages the workers who really, all of us are saying we want to help. And hence we're saying that let the amount be substantial enough, not to collapse the pension funds, etc. But 25,000 rand doesn't have the same value today. 50,000 rand we think is a sellable option, and most workers, when they've engaged them, have been appreciated that 50,000 rand wouldn't pay the bond or the car, but it could pay credit card debt, it could pay short-term loan shocks, etc., and help them begin to turn their life around. And we've always wanted to avoid depleting pension funds. We're trying to find the fair compromise, etc. But I think also to make the point, well, again, this is workers' money. It's not anybody else's money. And workers are also making a compromise here because in the future, you wouldn't have workers resigning to cash out. That would become a thing of the past. And so that's going to be a huge boost to the pension fund industry, because that's right now been the biggest depletion of pension funds is when workers resign, they change jobs, they cash out everything. I think that's why we see many, maybe more progressive pension funds come out publicly and endorsing it, saying this is a fair compromise. To Honourable Skosana, I mean, we've been having members here, Dr. George, the chair, many other members from this parliament and so forth, this committee, have had lots of engagement on it. I think we probably have had about maybe 4 or 5 rounds of public hearings on this specific issue, including on Dr. George's previous bill. And in 2020, we had an agreement with the Minister of Finance, Tito Mboweni, that time, we'll action this by 2021. We had this bill, the previous draft version of this bill came to this committee in September last year. So we think, Chair, and one appreciates, the pension fund industries will have significant logistical issues to address, to work out, but we shouldn't weigh that against the needs of workers who are drowning in debt, who are experiencing real hardship. Industries had enough time to prepare for themselves for this. And I think this is why Old Mutual, without me becoming a spokesperson for them, have come out publicly and said, yes, they're preparing, they're already adjusting the systems to make sure they are ready for 1st of March 2024. Workers are literally hanging on by the fingers. In the public sector, in the private sector, we should avoid frustrating them any further. And, it's fine to say, look, administrative issues are so great, they're so huge and immense, we can't do anything about it. The consequence of if you delay it is that workers will resign. And that's the thing all of us want to avoid. And I think it's not a scare tactic or being alarmist, etc. I think all of us in this room would know workers who actually have done that. And again, workers are compromising. They're basically sacrificing their resignation and cash out options in future. And industry is going to benefit in a significant way, make significant profits from it in exchange for some relief. So we think it's a very fair compromise to say, can the relief start from next year? We've had lots of discussions on it. I think part of the reason why these are tax bills, Chair, is precisely because Treasury wanted to assist to expedite these things through it and not a normal bill, precisely to make sure that we had the 1st of March next year being implemented. And when we even had met in September last year, a year ago, in the same hearings, the Treasury already gave notice we want to start this thing soon. So I don't think, Chair, it would be correct to simply say, let's kick the can down the road forever in perpetuity. It's not helpful, Chair. Workers are really hanging on for dear life. I think, Chair, just on the issue of the seeding, and it came back to the same issues Honorable Skosana is raising. We wanted workers to give some immediate relief because the pension fund was simply going forward from March next year. It would take workers 2, 3, 4 years, etc., to accumulate enough savings to make a difference. And again, you're then going to get back to the same crisis. Workers then choose to resign and cash out, which all of us don't want to happen. Hence, the kind of agreement with Treasury colleagues to say, let's give some immediate relief. What is a fair compromise? And I think, again, just trying to find the right balance and a win-win solution. It's not perfect, it's not beautiful, but we think on the balance, it's a fair compromise on all issues. On the issue of, and so hence the need for seeding to allow workers to have some immediate relief. On the issue of the 55 years, look, those workers are still working. Your retirement age is about 65. Those workers, like any other worker, are feeling the pain of the economy, etc. They should also be given some relief. They shouldn't be simply told, well, hang tight for another decade. Again, let's avoid the resignation issue, which you don't want. So I think lastly, Chair, yeah, for us, really, it's about 2 issues or 3 issues. One is about the immediate relief. Can it be made meaningful, not 25, let's say 50,000? Can we retain the existing tax rate, a fair compromise? And can we also we appreciate it's a lot of work to do, but we think it can be done. We shouldn't say to ourselves, we can't do it, hence let's give ourselves, once again, another year. Let's stick to the 1st of March next year, because, Chair, in essence, we've been having this discussion for almost half a decade. And that's the base in time. A person could have graduated from university. So we think it's a fair compromise. And at all times, we should really be guided by how do we assist the most poor, the most vulnerable. And they're in a crisis, not because they chose to be in a crisis. They're in a crisis because government's economic policies have not grown the economy. Business, too, has not assisted in growing the economy. And the consequence of that is that workers are paying the price. And we want to avoid that. And we also want to avoid a scenario where, for example, you find teachers or nurses, public servants, etc., resigning and further weakening the capacity of the state to deliver public services. I think, Vice Chair, we're very pleased with the bill. If we can just resolve the remaining issues of the immediate relief, the tax rate, and retain the 1st of March implementation date. And I think, Chair, it can really be a very positive fundamental transformation of the pension fund industry in a way which preserves savings, helps workers retire in more comfort, less poverty, and also we help workers in effect through a 13th check to pay down the debt, to survive, and in fact we'll also be helping to stimulate the economy through these cash injections. We think it is possible, and the fact that people like Old Mutual can come out publicly and say they're preparing, that gives us hope and that gives us confidence, Chairperson. But yeah, thanks very much. I hope we answered the questions. It didn't take too long.
Thanks, Comrade Matthew, for responding to the questions asked by members. Are there follow-up questions from members? Dr. George?
Thank you, Chairperson, and thanks for the comments on those questions. To Asisa, as you were talking, I was just making notes and trying to categorize the things that would need to be done for this change. And what I have here is that basically 6 key areas. It would be documentation and such as rules and then decisions of the board, that would be 1. Then processes and information technology, that would be 2. And then actuarial values and calculations, that would be 3. And then the administration load, that would be 4. And that member education and communication would be 5. And that intermediary and staff education and communication would be 6. Now, I know there's probably quite a bit underneath of those categories. And then when I look at that, it seems as if the key issue then is the process/IT, because obviously the industry relies very heavily on that. And also, as you said, to mitigate fraud, etc. So that seems to be the big one that would need to be climbed over. The others, I mean, yes, they are quite substantial. And yes, the industry's been through massive change when there was the mass conversions from defined benefits to defined contributions. But it did very elegantly manage that. So it is possible, we know, for the industry to evolve and adjust. But I think that's the key thing. And then, so it was more a comment than a question, but you've said you needed about 18 months to do this process. I mean, that's clearly too long. You know, if the 1st of March is not a possible next year, then what is in fact possible, given that, I mean, if it's correct that one of the large providers is in fact gearing itself up to be ready for March next year, then what is then feasible? Also, what needs to be borne in mind is the Government Employees Pension Fund. That's a large fund, as we know. And I suppose the question would be, they would have to do quite a bit of changes themselves. And I think that perhaps as a committee, we would need to find out how well they were doing on that. So yes, just for CISA is that, you know, my categories, I know they're not exhaustive, but it seems like it's the RT really that's the issue. And then what is practically feasible. And then for then Cosatu, on the withdrawal amount, yes, 25,000 is hopelessly too low, and it should be increased. I do hear the concern about the financial markets. I mean, you know, it's possibly over dramatic that, you know, we'd have instability in the financial system. I mean, you know, financial systems do absorb shocks to them. I don't think this is a shock. I think this is an adjustment, relatively small, but if it is quite dire, then it would be interesting to know, as a member of the committee, whether any work's been done on that. And specifically then, how would that make the financial system unstable? Once members have received this money, in all likelihood, they are going to spend it into the economy. So it might not be in one place, it would be in another place, but it would nonetheless be in the economy. So yeah, those are my comments. It's just then on the RT, if I'd have some comment on if that's the key issue, then if not 1st of March, then how long is a piece of string? Thanks.
Okay. Thanks, Dr. George. Asisa and Cosatu. Let's start with Asisa and then come to Cosatu.
Thank you. Yes, I think you've captured the biggest elements. What needs to be added is very important is the integration with the SARS systems. That is a big thing that needs to happen. And then also something that could take time, that is also a big thing, is the FSCA to approve all of the fund rule amendments. And rightly, I unfortunately don't have any information on the GPF, but a defined benefit fund, their administration systems to split, you know, to calculate pensionable service as a savings component and a retirement component. I can't think that that would be easy. So on implementation, I mean, some industry participants may have indicated that they will be ready. But at the end of the day, if everyone is not ready at the same time or don't start at the same time, then you will prejudice some over the others. And again, if you are ready and someone else is not ready, you can't transfer any of your funds if you change jobs or need to transfer to a different fund or a different retirement annuity. So the biggest problem with the limit on the seeding and the withdrawals is liquidity for the pension fund itself. And you will know that there are trillions of rands invested by pension funds, and the withdrawal from pension funds could have a severe impact on the liquidity of a pension fund, even for people who resign and leave and can take all of their money with them. That might cause a problem. So that liquidity management for a pension fund is a big issue. They will need to understand exactly how they're going to change the investment of their assets to be able to fund the withdrawals, in addition to what they currently have to fund when members resign or retire. I also need to stress that we've also been on this journey with Treasury since 2020. And although you can do some work with the framework that you have in mind, it is impossible to make the final amendments until the final legislation is promulgated. You can only put the final rules into a system once you know what the final rules are. So it's not possible to finalize everything until we have the finalized legislation. And that's why I emphasized that during our presentation, that we have sympathy. We also want to help, all of us here in this room, I'm sure, are members of pension funds or retirement funds. So we all want to facilitate that. But from a practical perspective, it is just not realistic. Thank you.
Thanks, Kosato.
Yeah, no, thanks, Chair, and thanks to Honourable Dr. George. Now, I think we appreciate the support around raising the 25,000 rand to a more meaningful amount, like 50,000. I think, apologies. Even the Dr. George's previous bill, I think we dealt with late 2020. He actually proposed a much higher amount, like 75%. And I think that time we were saying, okay, let's find a compromise that's a bit too high. Want to give relief but avoid around in the industry, for example. So I think all of us have been really trying to find the sweet spot, the right balance to helping workers today and also helping them with retire. So I think hence let's help these workers with something more substantial. When we've engaged, Honourable Chair, to some of our pension funds who our members are they've indicated that yes, they're able to manage a 25,000 rand amount easily. They're even able to manage a 50,000 rand amount. They don't think they could really go much higher than 50,000 rand. But they said in terms of their assets, they can easily do so. And I think, Chair, we should not also pretend that these pension funds are poverty-stricken. They have significant assets, not just lying around in petty cash in a desk drawer. It's invested and so forth, as it must be. But they can manage a 50,000 rand. This is not a small industry. The GPF alone is over 2 trillion rand worth of investments. Similarly, the other pension funds. So you're talking about a multi-trillion rand industry. They can afford, without us saying we must treat it like petty cash, but it can afford to give workers 50,000 rand caps. If we talk about an 18 months time frame, so let's say Parliament passes this bill end of November as a tax bill, President signs it by Christmas. So then we're talking about mid-2025, but because Treasury wants to link this to the tax year, then you're talking about a 2026 implementation date. So it would have gone from 2020 to 2026, 6 years to give workers some relief. We're talking about an additional 3 years from now in reality. And then whilst we don't want to encourage any worker to resign, we try to discourage them to do so. The reality is workers would end up doing so. And that's going to really undermine very progressive objectives. I think all of us collectively, governments, the industry, unions, Parliament, etc., we all want to avoid that scenario because it's the worst case. Chair, also, if one, and again, one can't speak for Old Mutual, but if one just looks at the website now, they're already giving information to members. And Old Mutual is not a small industry, small pension funds. It's big. They're already explaining significantly to their members about the March 2024 two-part regime. So it's clear that if there's will, one can move with speed. We're not sure how would we craft legislation which delays for the stragglers behind. because there'll always be somebody who will say, we need more time, we're not ready. And largely because industry also makes a profit. They benefit from it. Administrators make a commission, etc. We're also not sure, Chair, pension funds cash payout payments daily. So we're not sure what is the complication. We're not inventing new systems. It's a question of tweaking and readjusting and shifting and so forth. When I appreciate there's not a thing you do overnight. Hence, we had engaged with Treasury. Let's do this through a tax bill because it helps to expedite the parliamentary process. Let's find consensus on issues. Let's compromise and find each other. But we don't think, Chair, it would be correct to simply say, well, we must wait for the stragglers and then let's delay this thing to 2026. And that's in reality, that'll be then the closest you would end up doing it. And I think, Chair, that will just take a very wonderful thing, real hope for people who are drowning in debt and just frustrate workers. I think that's the worst thing we can do is to take people's hopes up and then let them crash down. And we've had this discussion, and I'm not sure why we simply want to continue to kick the can down the road and delay and frustrate workers in perpetuity. There is compromises, Chair, and even I think it's not a small compromise for workers to say that in future when they change jobs, when they etc., or if they want to resign, that option wouldn't be there. That's a major compromise. It's going to have a huge positive injection to the pension fund industry. It will benefit workers too because more will be preserved for retirement. But we think, Chair, it's only fair then to say what do we give workers in exchange for that real compromise on their part for the benefit of the industry and the economy, etc., etc. Yeah. Well, thanks very much, Chair. Thanks to members. Thank you.
Thanks very much, Comrade Matthew. We'll have to take the process forward. Tomorrow we are coming back for TALAB and TALAB. Tomorrow's meeting will be hybrid. And then from there, Treasury will prepare for responses. I think it will be in October. Because on Friday we'll be going away for a week or two and come back, I think, on the 9th of October. So that's how the process will be taken forward from now and then see what we can do. So Treasury has noted all the issues that has been raised by the stakeholders, and then they will respond at the right time. And then as Parliament, will take the process forward in terms of processing the bill. The meeting is adjourned until we meet again tomorrow at the hybrid meeting. Thanks.
Thank you.
Thank you, Chair.
Recording stopped.